Hi everyone, great to see so many people join us online. Welcome to this Mathys Squire webinar on Supplementary Protection Certificates in Europe, Part 1, which will be presented by Peter Arch, Alex Robinson, attorneys at Mathys Squire. My name is Saba Ismail, BD exec at the firm, and I'm delighted to be your host today. So without further ado, it's my great pleasure to introduce our presenters today, Alex Robinson, UK and European patent attorney. He handles matters in the chemical sciences with a focus on small molecule pharmaceuticals. His work includes prosecution of patent and SPC application, as well as contentious proceedings at the European Patent Office. Our second presenter is Peter Arch, UK and European patent attorney with extensive experience of drafting and prosecuting applications for pharmaceutical and chemical technologies and represented multinational companies at numerous EPO hearings. So without further ado, just hand over to Peter.
Thanks, Saba, for the introductions. I'm Peter Arch, the one on the left of these pre-coronavirus photos, looking rather smarter there than I am now after 3 months or so without a haircut. Alex, do you want to say hello quickly as well?
Thanks, Peter. I hope everyone can hear me. Yes, by process of elimination, you can see that I'm on the right there. I'm also undergone a bit of a corona transformation. So luckily for you, you don't have to see me while I'm presenting this, but I'll be alternating slides with Peter. So I think it's time to pass back to Peter to kick off with the first slide.
Thanks, Thanks, Alex. So this is the first webinar of a kind of two-parter. This one is intended as an introduction to the supplementary protection certificate regime in Europe. The second, as Saba mentioned, next week, we'll go into a bit more detail on some recent developments, recent controversies, and explain what's going on right now. Looking at today's webinar, we're going to start with the basics, the kind of fundamentals of what is an SPC, how do you apply for them, and what are the basic requirements. Then we'll go on to cover some of the more straightforward aspects of the case law. So in particular, SPCs are intended for medicinal products, and so we'll look at what an active ingredient is in a medicinal product for the purposes of SPC protection. We'll look at how combination products are handled, and then requirements for the marketing authorization, which you need in order to apply for a supplementary protection certificate. And then finally, we'll look at how many SPCs can be based on a single patent. One point to note before we start is that, as Saba pointed out, both Alex and I are chemists, so our focus is small molecules. But do bear in mind throughout this that all of this applies also to therapeutic compounds of a biological nature. The principles are all the same, but biologics tend to throw up a few further issues beyond those that we see in small molecules. So I will hand back to Alex to tell us what an SPC is.
Thanks, Peter. So in brief, an SPC is a patent-like right. It extends the protection that's conferred by the patent beyond its 20-year expiry date, but that's only to the extent that the patent covers the active ingredient or ingredients of an authorized medicinal product or a plant protection product. So that's agrochemicals such as pesticides, for example. What this means is that the SPC will generally provide similar legal rights and remedies that existed under the patent, but for a more limited scope of subject matter than covered by the patent, typically. Today, we're mostly going to be talking about medicinal products, as these are by far the most commonly sought type of SPC and the most common source of case law But the regulations for plant protection products, I should just mention, they work in essentially the same way. When I talk about a medicinal product, that could be a product authorized for human use, or it could be a product that's authorized for use in animals. And as Peter just said, it can be a small molecule or it could be a biologic. So the basic aim of the SPC system, as stated in the European Union regulation that underlies all of this, is to incentivize research into medicinal products by compensating for regulatory delays in bringing a product to market. That is, lengthy authorization procedures, which would effectively reduce the period during which you can enjoy the exclusivity under the patent while the product is actually on the market. It's open to debate whether it still achieves those aims in relation to how research works these days, but that's a topic for another day. So to get an SPC, first off, you need a marketing authorization for your product, and you need a so-called basic patent that protects the product that's authorized. And both of those need to be effective in the country where you're seeking SPC protection. When an SPC is granted, it will grant with what's called a product definition. Now, in some countries, that just corresponds to what's stated on the marketing authorization. In other countries, and this is the case in the UK, where we're based, other countries require you to actually provide a suggested wording for that product definition, almost as though it were a patent claim. Generally, if that's the case, we try and keep the definition as broad as possible, but it's not entirely clear whether the product definition actually has any effect on the scope of protection. If it's too broad, there is a risk that the SPC could be deemed invalid. That was the case in a decision a few years ago from the EFTA court. That's a court covering non-EU states, Norway, Iceland, and Liechtenstein. But the facts in that case were quite unusual. They're very specific to a particular vaccine strain, and it's not yet clear entirely how far those conclusions extend to other countries or indeed to other factual situations. So we won't dwell on that, but it's something to bear in mind. The actual scope of protection that's conferred by the SPC is determined based on a combination of what's claimed in the patent, what the authorized active ingredient or ingredients are, and what the medical indications that are authorized in connection with that are.
So as Alex mentioned, the SPC, you need a marketing authorization. You also need a basic patent. So what is a basic patent? Well, it's basically whatever patent you choose to base your SPC on. It has to be granted in the country, in the relevant country. So that could either be a granted European patent, which is effective in the relevant country, or it could be a national patent too. And basically, you're free to designate whichever patent you like. So this could be a patent which protects the active ingredient as such. It could be a patent directed to a process for obtaining the active ingredient, or it could be a patent which is directed to the therapeutic use of that active ingredient. So you have this free choice, but which patent should you choose? And there are essentially three main factors which need to be considered in making that selection. The first is the scope of protection. So as Alex just mentioned, the claims of the patent also limit the scope of protection of the SPC as well. So ideally, I mean, it's the broader the better. So claims directed to the active ingredient as such are obviously preferable in that respect to use-limited claims or claims directed to a particular production process. The second factor is the term of protection. So later patents, later files patents might, in some cases, provide a later SPC expiry date. But at the same time, you also need to consider how far beyond the expiry date of the relevant patent you're going. So you might get a later SPC expiry date by choosing a later patent, but the actual term of the SPC might not be that long. And in some cases, you simply can't use a later filed patent because there would be no SPC term or nothing useful. And usually there's a kind of inverse relationship between scope and term, because obviously your earlier filed patents are likely to be directed to the active ingredient per se, whereas the later cases are more likely to be limited to specific processes or medical uses. So a balance needs to be found there, bearing in mind how important the process is for a particular product, or how important any one medical use is, for example. Then the final issue is validity, by which I mean the risk that the patent or the SPC might be revoked or limited. So bearing that in mind, quite often it's the case that earlier filed patents directed to the active ingredient per se might be a bit more robust with respect to validity, but there is an issue here based on some of the recent case law that might not translate directly into a robust SPC, because it's required that the patent identifies the relevant product with a sufficient degree of specificity. So an earlier case might have a more robust patent, but actually it might not identify the product specifically. It might contain a Marcus structure or a functional definition or that kind of thing. So that needs to be considered as well. So I will pass back to Alex for the next slide.
Okay, so when we talk about SPCs today, we're generally going to be talking about the situation in the European Union countries. This is really it's an EU scheme originally. So the now 27 European Union countries share the same system, a common system, which is created by a European Union regulation. But within that context, it's important to note that the actual administration of that system is carried out at a national level. So although the underlying legislation is centralized EU legislation, when you're applying for an SPC, you would do that on a country-by-country basis, and that can lead to some variations in national practice as to what's deemed acceptable or what the timescales are, for example. The UK, as you're now hopefully aware, is no longer an EU member, but the SPC regulation has been transposed directly into UK law. So the system in the UK continues to operate just like it does in the rest of the EU, and it will continue to do so at least until the end of this year, when the transition period under Brexit comes to an end. After that, it's possible that we might see some divergence in the UK, but that is purely speculative right now. For the time being, the UK continues to function as though it's still covered by the EU system. It's also worth noting here that the SPC system is entirely separate from the European Patent Office. So although your SPC could be based on a basic patent which has been granted by the European Patent Office, there's no direct relationship between the two beyond that. One quirk that this sometimes turns up is that some of the countries that are now covered by SPC systems might not be covered by patents granted by the EPO, particularly if those patents are older. For example, Norway only joined the EPO in 2008. So that could influence your choice, or indeed the availability of choice for what your basic patent is going to be in some of those countries. For example, if both an earlier national patent and a later EPO patent are both available. There are also some countries in the EPO that aren't actually covered by SPC systems. Turkey is a notable example there. And finally, although it's mostly an EU system, there are other countries which have SPC systems very closely modelled on the EU system. In brief, those are the members of the European Economic Area, that's Iceland, Norway, and Liechtenstein. Switzerland, which isn't part of the EEA but has very close links to it, and in particular via Liechtenstein, and that can be quite important, as we'll see a little bit later, because Swiss SPCs automatically extend to cover Liechtenstein, and that can give rise to a few little quirks there. And then there are a few other countries which are mentioned at the bottom of the slide there, Albania, North Macedonia, and Serbia, which also have SPC regimes which more or less closely mirror that in the other countries.
So who may apply for an SPC? Well, the basic answer to that is the holder of the basic patent. In many cases, this is a different entity from the holder of the marketing authorization, but it is still the holder of the basic patent who has to apply for the SPC. Now, in most cases, this doesn't throw up any problems because there's usually a commercial relationship between the two. The marketing authorization holder might be a licensee or a subsidiary or that kind of thing. But there have been cases where this isn't the case, where a patent holder has tried to get an SPC based on someone else's marketing authorization without their permission. And this is referred to as the third-party issue. And there was a case in which the Court of Justice of the European Union commented that this might not be okay, essentially because it might be thought to undermine the objective of the SPC regulation, which is to reward the patent holder for bringing their product to market, essentially. So if they're relying on someone else's marketing authorization to do that, then it could be considered that they are relying on someone else's efforts to get the product to market in order to get the additional term offered by the SPC. That comment from the CJEU, however, was obiter, so it's not binding. And I mean, this issue was the subject of a referral, a specific referral to the CJEU in the Eli Lilly case, which is on the slide there. But unfortunately, that referral was deemed inadmissible for other reasons. But given the CJEU's previous comments, I think it's possible, even likely, that this issue will come up again. The final point on this slide is that the patent holder can only obtain one SPC for each product, a product being an active ingredient or a combination of active ingredients. It's essentially written in the legislation itself, but until recently, due to some case law from the CJEU, it was thought that it might be possible to get an SPC for a product per se, and then a further SPC based on the authorization of a further use. But recent case law seems now to have ruled out that possibility. So the basic rule of one SPC for a patent holder for a product seems to be the case now.
As for the duration of an SPC, that's set out by Article 13 of the EU regulation, which you can see there. It's quite wordy, but what this means basically is that the maximum term that's available for an SPC is effectively whichever is shorter of 15 years from the first marketing authorization, or 5 years from the expiry of the patent. And then paragraph 3 there refers to a possible extension of that, a 6-month extension of the SPC term, which can be available when a paediatric investigation plan is carried out. That's an investigation into the applicability of the authorized drug for uses in children. And I'll talk about that a little bit later. But I think first of all, Peter's going to walk through some example calculations to show how this works in practice.
Yeah, thanks, Alex. A couple of examples here. So example 1, here you have an 8-year gap between the patent filing date and the date of the marketing authorization. So you take that 8 years, you subtract 5, and you get a 3-year term for the SPC, which is essentially going to correspond to an expiry date which is 15 years from the date of that marketing authorization on the 1st of January 2009. The second example, there's a longer gap between the filing date of the patent and the date of the marketing authorization of 13 years, and at this point you start to hit the 5-year cap. So you have that 13 years, you subtract 5, you get 8, but that's more than 5, so you just reduce it down to the 5-year maximum. One point to note here is that all of these dates, well, it would be it wouldn't matter for example 2, but for example 1, you're looking at the notification date of the marketing authorization. So at least with authorizations granted centrally at the EU, the authorization has a grant date and then it has a slightly later notification date, the date on which the marketing authorization holder is informed of the grant. And usually there's a handful of days between the two, so somewhere in the region of maybe 2 days to 8 days, something like that. And the term is calculated based on the notification date. Now that hasn't always been the case. That was decided in a CJEU decision a few years ago. So up until that point, some of the national offices were calculating the term based on the grant date rather than the notification date. But in those cases, if you have an SPC which has been granted based on the grant date of the marketing authorization, you can request correction of that at the national office. The final point to be aware of is that the relevant date is the first marketing authorization in the EEA, so that includes the EU as well. So that means that if you get a marketing authorization in Iceland, for example, then that starts the clock running in terms of the duration for the whole of the European Union. And that can obviously be a disadvantage if you're getting a marketing authorization in a country with a relatively small market, for example, Iceland, but actually that marketing authorization is essentially shortening the SPC term for the whole of the European Union. And a particular problem here, a bit of a trap, comes with Liechtenstein and Switzerland. So a Swiss marketing authorization doesn't in itself form the basis of the duration calculation because it's not a member of the European Economic Area. However, a Swiss marketing authorization does automatically extend to Liechtenstein, which is a European Economic Area member. And so that marketing authorization in Liechtenstein can effectively shorten the SPC term for the whole of the EU. This problem can be mitigated by placing your marketing authorization on something called the negative list This essentially delays the automatic effect in Liechtenstein, so that you can avoid that detrimental effect on the SPC term. And back to Alex to discuss paediatric extensions.
Thanks, Peter. So, as I mentioned earlier, an extra 6 months of protection under the SPC are available if a marketing authorization application includes the results of studies conducted in compliance with what's called an agreed paediatric investigation plan. Now, that's actually the case regardless of whether or not the paediatric indication that is the subject of that plan for research is actually authorized or not. So simply for carrying out the research under that plan, you may be entitled to benefit from an extra 6 months of SPC protection on top of whatever the initial duration is. So you don't need to have the full 5-year term of protection under the SPC before you can benefit from this extra 6 months. It's 6 months plus whatever you got under the SPC originally. And that means that, for example, in some cases where, based on the calculation that we saw a few slides ago, the duration of the SPC might be 0 years, or it might even be a negative number of days if you compare the relative grant dates of the marketing authorization and the patent. That can still be beneficial if you then obtain a 6-month extension via the paediatric route to bring a 0 or negative term SPC into a positive duration. So that's always worth bearing in mind. In some cases, that extension isn't available. So if, for example, you have an orphan designation for your medicinal product, you're not entitled to the paediatric extension. Instead, you get a different reward, which is an extra 2 years of market exclusivity. So that's effectively a regulatory mechanism by which generics are prevented from entering the market. So in those types of circumstances, you might want to consider whether or not you would benefit from better protection under those extra 2 years, or whether the SPC plus 6 months would give you extra protection. And if so, you might want to consider withdrawing the orphan designation. It's not entirely clear in the case law, but it seems at present that that's allowable, although there should be a health warning attached to that could be subject to change. There's not much case law on that. In other cases, you might have a choice between a pediatric extension or an extra 1 year of marketing exclusivity. It's either or, you can't have both. And the availability of that extra year of marketing exclusivity depends on something that's called a significant clinical benefit being demonstrated with the product. Now, that isn't actually very well defined in the regulation what that means, and to the best of my knowledge, that hasn't actually yet been tested in the case law. But in principle, under those circumstances, you might have a choice. And again, the relevant factors to consider there might include what the relative expiry dates would be in those two circumstances.
So how do you apply for an SPC? Well, you apply to the national intellectual property offices in each of the separate states. There are various documents required and information as listed here on the slide, which I won't just read out for you, but you can see what's required there. I think just one point to note, due to the absence of kind of central application process, because this is split up between national intellectual property offices, they tend to develop their own practices and their own, as well as their own interpretation of some of the legislation and the case law. So in some countries, it's almost a rubber stamp exercise. You apply for an SPC, and in a matter of months, it comes back with a stamp on it saying, yes, there you go. Some countries just don't examine for certain substantive requirements, whilst others examine very rigorously. So that means you can get divergent results across the European Union, which is, to be honest, not really what the aim of the regulation is, because the idea of this being an EU regulation is to get consistency throughout the internal market. But unfortunately, that in complex cases is often not achieved. So you can get different results. In terms of the prosecution process, I mean, that differs very significantly between the different countries as well, in particular in terms of timescale. In some cases, some countries, you can expect your application to be examined almost immediately. In other countries, there's a significant backlog, and in at least one or two, I think there's a policy of essentially waiting until the last couple of years before expiry of the basic patent. So you only know whether or not you're going to get an SPC quite close to the time when it's due to come into force.
So the question now is when to apply for an SPC. This is relatively straightforward. The SPC application has to be filed by whichever is the later of 6 months from the date of grant of the basic patent. So that can constrain your choice as to which patents are available, perhaps, or 6 months from the date of grant of the marketing authorization that's effective in the country where the SPC is sought. That shouldn't be confused with the first marketing authorization in the community, which sets the duration of the SPC. There could be situations, particularly if the authorization has been carried out under a national procedure rather than the centralized European Medicines Agency procedure, where those authorizations might not be one and the same. There have been cases where an authorization or where an SPC has not been available because the patent has actually expired before the marketing authorization has been granted. There was a case a few years ago, for example, where the patent was about to expire and the marketing authorization, what had been received was a so-called end of procedure notice, basically indicating that the conditions for grant of an authorization had been met and the authorities had agreed to grant one, but it wasn't yet in force, and it wouldn't be in force until after the expiry of the patent. And unfortunately, in that case, the SPC just wasn't available, so that is quite strictly interpreted. The SPC application can't be filed before the patent grants or after the patent expires. So it has to be filed while the patent is actually in force, but it doesn't then take effect until after the expiry of the patent. It will be granted, as it were, provisionally, so that it comes into effect when the patent itself expires. And just as a note, the assumption at present that is that the 6-month period from the date of grant of the marketing authorization should probably start from the date of notification, similar to how the calculation is performed for the SPC duration. But there's probably no need to take that risk. As a safeguard, you should probably assume that the filing date should be based on a 6-month calculation from the date of grant, not the date of notification.
So that's the basics dealt with, and now we're going to move to some of the more straightforward case law, if there is such a thing. Unfortunately, this has to come with a bit of a warning that this is a particularly unclear area of law. And the basic reason for this is that the legislation itself is not particularly clearly drafted. this has resulted in national courts frequently referring questions to the Court of Justice. And unfortunately then, the answers which have been provided have not been particularly clear themselves. So there's often confusion as to how broadly these decisions are applicable or how restricted they are to the particular facts of a case. And this culminated in one national judges getting quite frustrated with the situation, and indeed a former UK Court of Appeal judge in particular described one decision as close to gibberish. In my personal view, I think the situation is getting a bit better with some of the recent decisions. There has been a little bit more clarity injected, but unfortunately this, well, depending on what your point of view, unfortunately this has generally been to the detriment of SPC holders. And in one very recent case, the decision, although providing what appears to be clarity, it seems to be an outright reversal of a previous CJEU judgment. So the basic point to take away from this is that reading the legislation itself doesn't necessarily give you the right answer. Don't assume because the regulation says something, it actually means it, because the case law in some cases just directly contradicts the literal wording. Thanks, Alex.
Thanks, Peter. So having had that health warning about the clarity of the literal wording versus what's in the case law, the question of what is an active ingredient, thankfully, is a relatively straightforward one. That is definitely defined in Article 1 of the regulation there. A product is the active ingredient or combination of active ingredients of a medicinal product. That tends to be construed quite narrowly, as we saw in recent cases concerning, for example, medical indications, new medical indications for old drugs, for example. It should be noted here that the what's deemed to be the active ingredient is not limited to the particular pharmaceutical formulation that's authorized. So if your authorization covers a particular presentation of the drug together with particular excipients, for example, or carriers in a particular dosage amount, or let's say in hard capsule form or something like that, that isn't deemed to form part of the active ingredient for the purposes of the SPC. It is limited to the pharmacologically active component or components.
So a bit of case law now on the question of what an active ingredient is. And this question tends mainly to arise in attempts to get SPC protection for combinations of products where it is questionable whether one of the ingredients in that combination is actually an active ingredient. So in the MIT case, there was an application, well, there was a marketing authorization for a particular cytotoxic agent together with a bioerodible matrix. The cytotoxic agent itself was the subject of a much earlier marketing authorization, which couldn't be relied on. So the applicant was relying on this combination. And the question was whether this constitutes a combination of active ingredients. So whether the bioerodible matrix itself is also an active ingredient. And the argument which was submitted here was that the matrix was actually necessary to avoid toxic effects. So it was necessary, a necessary component of the product to provide the activity. The CJEU rejected this argument, and the test which they applied was basically, does the ingredient have a therapeutic effect of its own? So So a substance which does not have any therapeutic effects of its own is not covered by the concept of active ingredient. So in this case, the bioerodible matrix was not an active ingredient. The second case here, the GSK case, the question was whether a vaccine adjuvant was an active ingredient. And they tried to distinguish here from the MIT case above on the basis that the adjuvant did itself have a physiological effect on the body. But the CJEU stuck to its line. The requirement is for a therapeutic effect of its own. So on that basis, the adjuvant was not considered as an active ingredient. So the combination of vaccine with adjuvant was not considered to be a combination of active ingredients, which could qualify as a medicinal product. Sorry. Here we go. Thank you, Alex.
Thank you, Peter. Picking up on that point about active ingredients, the so-called Foursquare case was quite an unusual one, which perhaps gives us a little bit more clarity on maybe a slightly broader definition of active substances. So in this case, the marketing authorization related to a vaccine that included a polysaccharide that was covalently bonded to a protein which acted as a carrier. Now, that protein had its own therapeutic activity, albeit not against the same medical indication as the polysaccharide. So you can see this is quite unusual here, that you've got two separate moieties, which each individually have their own therapeutic effects potentially, but only one of those is relevant for the authorization at issue. Now, in the decision here, the CJEU suggested that a therapeutic effect might not be necessary, that something having its own immunological or metabolic action, but no therapeutic effect, could also be deemed to be inactive for the purposes of the SPC regulation. Now, unfortunately, that hasn't been followed through. As far as I'm aware, there aren't any cases that have directly followed this, because in this case, the SPC wasn't granted anyway, because the therapeutic effect of the active ingredient, the polysaccharide, and the therapeutic effects of the carrier, the protein, were different, and the effect of the protein wasn't covered by the marketing authorization. So the SPC in this case wasn't granted, but there is potentially a hint there that the definition of activity might be slightly broader than we previously thought. As ever, it's not yet known how narrowly that decision is going to be constrained to the facts of that particular case, but is certainly one to bear in mind. Back to you, Peter.
So the substantive requirements for an SPC are in Article 3 of the regulation. Article 3A requires that the product for which you're trying to get an SPC is protected by a basic patent in force. At first glance, that looks simple enough. As a patent attorney, I think I probably know what the word protect means. Unfortunately, it's not quite so simple. In the world of SPCs, protect does not mean what I think it means as a patent attorney. So over recent years, this issue has probably been the greatest source of confusion in the case law. And it all started with a case about combination products, which I will hand back to Alex to explain.
Thanks, Peter. So in 2011, there were essentially, I think it was 3 cases decided at more or less the same time, which concern different patterns of facts regarding combinations of active ingredients, different situations with regard to what was specified in the marketing authorization, what was specified in the claims of the patent, and what the SPC that was being applied for was supposed to cover. So I'm going to sort of just quickly run through this table here and then hand back to Peter to let you know what the outcome was. So in the first row, we've got quite a simple situation, no surprise there. Hopefully that we've got a patent claim which is directed to product A, a marketing authorization which is also directed to that same product, and an SPC application which was looking to obtain protection for the same product as well. That's a fairly clear yes, the SPC in principle is allowable. But then we get to row 2, for example, where the patent protects the product in the sense that the combination would infringe what we normally think of as patent protection. But is that enough to allow you to get an SPC directed to that same combination, A plus B, that isn't mentioned in the claim? Row 3, you've got a claim that covers A plus B. This is in a way the inverse of what's going on in row 2 there. So the claim explicitly is directed to a combination of 2 actives, but the marketing authorization is directed to just one of those actives, and you're applying for an SPC for that active on its own. So a question arises as to whether or not that's allowable. And then in the final row, we've got a patent and an SPC application that are consistent with one another. But the marketing authorization requires the combination. So what is the answer there? And Peter's got the slightly unenviable task of trying to explain what the outcomes were in those cases.
Well, I'll just put the slide up. No, yes. Essentially, the test is not a hypothetical infringement test. So protect doesn't mean protect in the sense of that it might do in an infringement sense. What the requirement is that it is specified in the wording of the claims. So in row 2 here, the SPC to the combination is not allowable because that combination isn't specified in the patent claim. Likewise, in row 3, the SPC directed to the single agent also isn't allowable in that case because the patent claim includes something else as well. So the single agent isn't specified in the wording of the claim. But in the last case, in row 4, the SPC is allowable because the patent claim and the SPC are consistent in being directed to A alone, regardless of the fact that the marketing authorization requires the combination with B. That does, however, leave open the question of how specifically the product has to be identified in the patent. And that is a complicated question, which we'll be following up on next week in part 2 of this series.
Just a quick note on the marketing authorization. I think we've covered quite a lot of this already, but just to recap, the authorization needs to be valid. So as we've heard, it can't be an authorization that's still pending. It needs to be the first authorization to place the product on the market. And the duration of the SPC is based on that first authorization. Part of the requirements specified in Article 3B there have to do with the particular directives under which the authorization has been granted. So back to Peter for the details of that.
Yeah, so a couple of points to note here. The first is that there is a specific reference in the regulation to certain directives. Now, these directives are the ones which relate to the authorization of human and veterinary medicines. Essentially, what that means in practice is that, broadly speaking, medical devices which are authorized as medical devices are out. So that's, you get some cases, for example, drug-eluting stents, where there's a device and an active substance which is kind of ancillary to the effect of the device. If those products are authorized under the medical devices regime, then you can't use that authorization to get an SPC. The second point to note is that the relevant authorization has to be the first authorization for the product. So for a number of years following the CJU's NURIM decision, it was thought that actually you might be able to get an SPC for the product per se, and then if a new formulation or a new medical indication of that product was authorized, you might then be able to get a further SPC. That appears now not to be possible following some recent case law. So authorizations for new formulations or for further medical indications, we now think are probably ruled out.
I can see we're running a little short of time here, and we want to leave a bit of time for questions, but just very quickly, we're going to touch on the question of how many SPCs you can get based on any given patent or for any given product. So in brief, the wording of Article 3A would seem to suggest that if another applicant has already obtained an SPC for a given product, then you can't have one. But then we have Article 3.2 here, which is actually from the regulation on plant protection SPCs, and that's incorporated into the medicinal SPC regulation by reference. This clarifies that the general rule is one SPC per applicant per product. So just because somebody else has got an SPC for the same product doesn't in and of itself preclude you from getting one as well.
So the basic rule is one SPC per product per applicant. And this slide just clarifies that in spite of the wording of the regulation, that applies kind of regardless of whether the SPC applications are pending at the same time. So if someone else already has a granted SPC to the product, that should not preclude a different patent holder from also obtaining an SPC for the same product.
I think this is our final slide. This touches on some of the issues that we're going to be considering next week, but you can imagine a situation where a patent protects in the sense that it specifies in the claims both a single active ingredient and a combination of that active with another active. The case law on this is really quite confusing and specific to the facts of each individual case. In general, it's okay to have more than one SPC per patent, but as a requirement for that, each of the products that you're trying to seek SPC protection for must be protected as such by the patent. There's some case law suggesting that means that the product has to embody the core inventive advance or the subject matter of the invention. Basically, what that seems to mean is that if your combination is only protected by virtue of quite generic wording, such as optionally comprising additional ingredients, for example, or just defining a very broad class of actives such as diuretics, which came up in a number of cases, that might not be sufficient for it to be deemed protected as such by the patent. I think we should note here that the validity of that test is now actually quite doubtful. There's been some recent case law, which we'll be discussing next week, which suggests that perhaps a stricter standard might apply, and I think that is a suitable cliffhanger to leave you waiting on.
So just finally, some takeaway messages. up to 5 years additional protection, or 5.5 with possible pediatric extension. The applications have to be made at a national level because there's no centralised application route. And the most important decision to be made is which basic patent to use for your SPC application. And that last point on the unclear case law, that's one that we'll be covering in a bit more detail next week. Okay, so I think our time is up now. So thanks everyone for joining us. I hope you enjoyed it. I hope we were clear, and I hope that lots of you come back next week for part 2 as well.
Brilliant. Thanks, Peter and Alex. Just take this opportunity to mention that you'll be redirected to a feedback form, and we would really love to hear your thoughts about this webinar and any other topics that you feel like we should be covering for the future. As mentioned, as you can see from the slide, Peter's and Alex's email addresses are there. Please do get in contact if you have any questions following this webinar. And just lastly, just to say thank you and take care. Thanks, everyone. Bye.